Okay, today's Monday, August 20th, Julio Zamora. I'm going to bring up the fact that Safeway is in violation of everything in the contract. The union didn't follow contractual procedure. Um, they they discriminated. They didn't accommodate me. Um, I filed 132As in harassment. Also, they wrote me up for, they sent me home on December 7th, 2010. Nothing in writing or whatever the reason is or what they're going to do in the future. Just sent me home. Didn't honor offer of work and FMLA. For 1 year, the offer of work was good for 1 year of work. Whether I accepted or not, I was to work 1 year with an accommodation for severe profound hearing impairment, and the FMLA was for a serious health condition. On December 17th, they sent Safeway sent a letter to the union. On December 17, 2010, Safeway letterhead stamp received Local 439, December 17, 2010. Okay, and that was it. We won't go into registered mail or mail because there was very little of it. They were instructed to produce evidence proof by December 25th and to set a date and time for a panel hearing at Safeway in Tracy, California. Safeway set the time for the panel hearing on January 11, 2011. That's 35 days from December 6, 2010. So they haven't responded in 35 days, period. The letter for September 18, 2009 dealt with the company time clock in the driver's room. The reason for the time clock in the driver's room is to work the drivers longer and not pay for the miles. When they log out of their truck in Tracy, Livermore, like I was in Eureka, log out, then they bring you back or your driver pick up back in violation of the DOT regulation. The clock is there to undermine the Department of Transportation and not pay for the difference in miles. They only pay you for the miles on the trip sheet. And also they don't pay from the tractor to the clock in the driver's room. The driver should get paid the difference. Okay? So that's the reason for the time clock in the driver's room. And the clock in the driver's room doesn't print out logs. Okay? Now you have a data computer and the tractor, which prints out logs in the master computer. They're not to be touched, altered in any way. If they're touched or altered in any way, they have to have my permission to do so. It wasn't given. They just took it upon themselves to change the time from 10:30 to 11:15. It's true they have a company policy to change the time or alter the time on the time cards, employees' time cards, on company policy. On DOT regulation, you're not allowed to do that. And the company is not allowed, the DOT didn't give them permission to alter the logs at any time, place, or whatever. So that they did. So if he says he has permission or authorization to change the time in the logs, it's not true. Unless he can show me under the regulation where it says he's allowed to do that. Under the Department of Transportation on an automatic onboard recording device. That wasn't being done. So again, for the last time, the clock in the driver's room has nothing to do with the computer and the tractor. And they don't pay you for the difference in miles. They don't pay you from the tractor to the clock in the driver's room. And you have to take 10 hours off from the clock in the driver's room. And it should be 10 hours off from the tractor. And you're not to be delayed from leaving. That's a DOT regulation. It's not, it's undermining the Department of Transportation. So that's I like to bring that out. It's important. It's important to note again that they violated everything in the contract, and they denied me arbitration. Okay, they denied me arbitration. I should also note no one spoke to me in 3 years. Maybe Mr. Nicewanger once or twice, but that's it. Not Safeway. No meeting with Safeway, whatever, other than the panel hearing and the hearing on the management hearing on December 7, 2010, which was completely different than what the dispatch interrogated me for. Okay, and he didn't take me to the bulletin board and show me exactly what was posted in 2009, and this was 2010, so I'll never know if there was a posting. And the shop steward didn't let me log out, and it doesn't show me logged in, which I clocked in the driver's room, and it doesn't show it on the logs. So how can the September 18th posting be reliable if it doesn't even show me on duty on the logs? So that's my confirmation that the clock does not have nothing to do with the computer and the tractor. Again, I'm going to say that again. I logged in on December 7, 2010. Okay? It doesn't even show me being there or clocked in on my logs. But yet, they're going to send me a letter from December 17, 2010, all the way back to December 6th, and I was already escorted off the property, and they violated workman's comp 132A and harassment. And I would say that it was a retaliation. And the insurance company also retaliated by sending me denial of everything on December 7, 2010, saying that it's not an on-the-job injury, when in fact I have a QME report that says it is. So the clock in the driver's room doesn't record, doesn't do anything except undermine the Department of Transportation and not pay the drivers difference in miles and the time from the tractor to the clock in the driver's room. And again, they should get paid for that because they have to get 10 hours off from the clock in the driver's room when it should be from the tractor. And they're not getting paid. They lose the time that they should have left the company to go home and go to bed and take their 10 hours off and come back. But they're being prevented from doing that. So they should get the difference in pay because they're still on duty. And they're not getting paid. So, that's about it. We'll send this to my attorney. I haven't, I don't know if she's going to take my case or not. I had a demand for arbitration. So, that being said, end of story. This is just a notation about the clock in the driver's room is there to undermine the Department of Transportation when you're already on duty when you come to work. You're already on duty for 14 hours according to the Department of Transportation. End of story.